allow the children to have them before the revolution.
It's okay. Off your mind. It's okay.
She
Off your mind. Off your mind.
like me.
Chai! Now wow, people wey suppose talk truth to power don off mic. And if we talk, now 500,000 they go sama us, call am hate speech. But fear not, Mayegun don come. Him go torchlight every corner, nooks and cranny of all these bad people where they spoil our country. So my people make we laugh, oh yo yo. Mayegun don come, oh yo yo. My people make we shout, oh yo yo. Mayegun don come, oh yo yo. Mayegun don come, man of the masses, oh yo yo. Mayegun don come, oh yo yo. Mayegun diary politico, oh yo yo. Mayegun don come, oh yo yo. This one not the off in mind, oh yo yo. Mayegun don come, oh yo yo. Can in the touchlight every corner, oh yo yo. Mayegun don come, oh yo yo. Okay, some people be they holla say they want the power. Chai, them be promise us say we go get light and power. Nah. Them hustle so they can't get the power. But now they know they do anything with the power. Sure. Every day, dollar just they get the higher power over naira. Still them talk say make we off mind. But thank God say Mayegun don come. So my people make you laugh, oh yo yo. Mayegun don come, oh yo yo. My people make we shout, oh yo yo. Mayegun don come, oh yo yo. Mayegun don come, man of the masses, oh yo yo. Mayegun don come, oh yo yo. Mayegun diary politico, oh yo yo. Mayegun don come, oh yo yo. This one not dey off in mind, oh yo yo. Mayegun don come, oh yo yo. Person wey dey do evil no wan make person talk. Them say that Mayegun, that man too they talk. He too they talk. Say Mayegun diary, he dey hot like pepper. But every day then they take money in bulk. Woman pikin dey the street they hawk. Still them talk say make we no talk. But thank God say Mayegun don come. So my people make you laugh, oh yo yo. Mayegun don come, oh yo yo. My people make you shout, oh yo yo. Mayegun don come, oh yo yo. Mayegun don come, man of the masses, oh yo yo. Mayegun don come, oh yo yo. Mayegun diary politico, oh yo yo. Mayegun làwa mọ̀ làmọ̀ tó dòdòdò.
Mayegun diary, Mayegun number one.
Mayegun làwa mọ̀ làmọ̀ tó dòdòdò.
Mayegun diary, Mayegun number one.
Mayegun ti dé o ọ̀rẹ́ ara ìlú.
Mayegun diary, Mayegun number one.
Lórí Facebook, lórí YouTube.
Mayegun diary, Mayegun number one.
Gbogbo bó ṣe ń lọ ni Mayegun já wa sí.
Mayegun diary, Mayegun number one.
Àṣírí ọ̀jẹ̀lú kì í bò níbẹ̀ o.
Mayegun diary, Mayegun number one.
Bó bá ṣe eré àní Mayegun máa wí.
Mayegun diary, Mayegun number one.
Ó sì tún ṣe eré wàá gbọ́ níbẹ̀ o.
Mayegun diary, Mayegun number one.
Mayegun diary, diary politico.
Mayegun diary, Mayegun number one.
Godfatherism kò sí lọ́rọ̀ Mayegun.
Mayegun diary, Mayegun number one.
Ẹ farabalẹ̀ sẹ́ o kẹgọ́rọ̀ lẹ́nu o.
Mayegun diary, Mayegun number one.
Àní Mayegun làwa mọ̀ tó dòdòdò.
Mayegun diary, Mayegun number one.
Àní ẹ̀sùn ràkì.
Mayegun ti dé. Mayegun ti dé.
Ọ̀jẹ̀lú ẹ̀sùn ràkì.
Mayegun ti dé.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Lórí Facebook.
Mayegun ti dé.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Lórí YouTube.
Mayegun Máyégún ti dé.
àní ẹ̀sùn lájú.
Máyégún ti dé.
bọ́ bàbá gbé wúrẹ́.
Máyégún máa wí.
àní ẹ̀sùn lájú.
Máyégún ti dé.
ijó ìgbádìyẹ.
Máyégún máa wí.
àní ẹ̀sùn lájú.
Máyégún ti dé.
pẹ̀sìdó bá rúfin o.
Máyégún máa wí.
àní ẹ̀sùn lájú.
Máyégún ti dé.
Jẹ́ Máyégún máa wí, àní ẹ̀sùn ra kì í, Máyégún ti dé. Hello there. Good morning to you. Good afternoon to you. And good evening to you from wherever you are joining us. This is brunch time with Máyégún live. I bet you can hear me loud and clear. Can you? Thank you. Brethren, welcome to the temple of truth, the temple of uncomfortable truth. Read the caption of this broadcast. Read the description as well. Like it, share it, invite your friends, invite your not so friendly friends. Tell them that Máyégún today, and you do know why we are here. It is to complete the reading of the controversial best-selling book or bestseller book, Nigeria and its criminal justice system, a judiciary saddled with unjust people, criminals, justice traders, manipulators, corrupt rogues who have thrived in this system for so long that they have built reputation for themselves, the reputation that they fear this book is ruining. It is too late now to stop the sale of the book. Over 100,000 copies of this book has made it to the hands of over 100,000 people around the world, in Nigeria and outside Nigeria. So Afe Babanlaole is a gang and crew and those who are working as his proxies. They acted very late. Even though they agreed in their shamelessness, they are asking, not just asking for the stoppage of the publication of the book, distribution of the book, they are asking their useless courts in Nigeria to order the proceeds from the royalties from the book sale to be given to Afe Babanlaole, the greedy, selfish old cretin in Ekiti. So what pissed them off? How did Dele Farotimi press the rage button of the career criminals in Nigeria, young and old? What did he say? What exactly is in that book? To those of you who have read the book, and to those of you who haven't, whatever it is that triggered these guys so mad, that got them so crazy, the action of Afe Babanlaole and their collective criminals in Nigeria has prompted tens of thousands of people around the world to go buy the book. Without them, a lot of you will probably never be interested in what is written by Dele Farotimi. Many of you won't. It is obvious that the actions of these guys in the last 1 week has further given credence and credit to this book, right? Because everything that Dele Farotimi postulated in this book has played out in the last 1 week, which now justifies publication of this book. And it has been the driving force for its sale all over the world. Not just Nigerians are the ones buying this. Even non-Nigerians are buying it. It is the best-selling book in the whole world right now. Yes, it is. And the way they are going with the impunity in that system, where Dele Farotimi has been incarcerated, locked up, denied bail, and they are instituting different cases all over the place, shows that Dele Farotimi has triggered the establishment to try to want to bury him. But he said it in his own words. He said, if I must self-immolate for you to behold the extent of the rot in Nigeria, so be it. Right? I know. Milady, Liz, that's what I'm saying. The book has been published. It would have been published since last year, 2023. Dele Farotimi said he kept the publication till later, so that nobody will come around and say, oh, because he supported Peter Obi and because they rigged him out, that is why he went to go and write a book. So he said this book is it's been in the pipeline. The work on this book has been in the pipeline for 11 years. So it wasn't something that he just woke up and decided to just, okay, you know, I'm going to write a book. No. But he did a great job here to tell us, not just about the Nigerian judiciary and how corrupt it is, but those who are responsible for the sustainability of that corruption and how they have shaped the direction in which the Nigerian judiciary has taken, the direction of a partition. The Nigerian judiciary is responsible for the criminals who are currently running governments in Nigeria to have legitimacy, the corrupt judiciary in Nigeria, as well as the likes of Afe Babanlaole and his likes, including Ironipekun, the madman that represented Tifnumbu during the presidential, the presidential tribunal, the presidential election tribunal, presidential Supreme Court case. The man that told us that is a senior lawyer, he said, because Tifnumbu's Guinean passport expired, that simply means Tifnumbu's citizenship of Guinea had expired too. A senior advocate of nuisance in that contraption. They are also the same, where I say, if you have been for any reason involved in any criminal activity, you cannot be president of Nigeria. They said the drug dealer, heroin trafficker, drug himself, the drug addict, Tifnumbu, certificate forger. They said the case is old, it's over 10 years. That it doesn't really matter. The same rogues in the Supreme Court. You see, it is a collection. Yesterday, they announced that one Ogunwumiju, look at this on your screen, right? The guy that sued Dele Farotimi for 500 million naira, working for Afe Babanlaole, Kehinde Ogunwumiju, is adjudged to be the youngest person to become a SAN in Nigeria. Okay, normally to become a SAN in Nigeria, senior advocate of nuisance in Nigeria, you must have some amount of cases that you initiated and you won through the federal, whether it's going to be from the state high court, federal high court, appeal court, the Supreme Court. This guy, after 3 years of being called to bar, he became a SAN. That is the guy, right? We have no record of any of the cases he won, but his name is attached to some of the cases initiated by the chamber of Afe Babanlaole. And his mama is a Supreme Court judge. Here you get. His twin brother, Taiwo Ogunwumiju, is APC, Egbekegbe's member of the Ondo State House of Assembly. Do you see the pattern? Their mama be Supreme Court Justice, right? Elaine Morenikeji Ogunwumeju, the mofo, the mad woman that said, despite all the evidence we saw on screen during the during the presidential tribunal case, when the Obi Atifku, when they are carrying boxes of evidence to the court, now that mad woman talks say Peter Obi Atifku, they did not present any evidence to support their case against Tifnumbu. Atifku presented the what's that place called again? The Tifnumbu's alleged school in America, Chicago State University, including the entire rigging process, how it was done. They presented all of this, but they said because this evidence were not presented at a certain time, so therefore they could not admit them as evidence. Now that mad woman can't read her own judgments in support of Tifnumbu, that Obi did not present any evidence, Atifku did not present any evidence, that Tifnumbu was a drug dealer in America. It's just a speculation. That INEC turned off IRF and rigged the election. They were just speculation. That Obi and Atifku were expecting them, Supreme Court, to help them manufacture evidence. Evidence that we see for TV. So you get, but it's obvious anyway. She's APC, Egbekegbe member. Her son is APC, Egbekegbe member. Then another son, Kehinde, is working for Afe Babanlaole. Do you get the old logic now? So Dele Farotimi knows that he will probably never get justice. However, he said, if I must self-immolate for you to behold the extent of the rot in Nigeria, so be it. So do you see what you are up against right now? The reason why you will never see any justice in that contraption is because those interested parties, the interested, the people of interest in that contraption, they are more evil than you can imagine. So that's why we have to give it up for Dele Farotimi. Do not feel sorry for him. Do not cry for him. Just cry for yourselves. Because you see, whatever it is that they plan to do to him, he saw it coming. Have you forgotten? Days before his kidnapping and abduction from Lagos, he told us. A reminder.
It came to my knowledge that there is a charge that had been fraudulently preferred against me before a court in Ekiti State at the instance of Chief Afe Babanlaole. This charge had been fraudulently preferred, hidden from view, and the court had purportedly demanded my presence multiple times, and I had failed to appear before this court. And this court had then proceeded to issue a bench warrant for my arrest. This is classic Afe Babanlaole. I detailed his corruptive influence in my book, Nigeria and its Criminal Justice System. And what he has done is exactly what he has always done in hiding. But he has done it this time again. And the calculations were that I would have been picked up, taken before this judge who must have either been compromised or misled in Ekiti. And I would have been remanded in prison custody for being somebody who was meant to face trial and who had refused to bring himself to court. I am reliably informed that social media influencers had been paid to spin these narratives after my arrest. Human rights activists have been positioned to start speaking after my arrest, including one Agbaya. High offices in this country have been compromised in pursuit of my person. High offices, from the Inspector General's office, because the police have been subverted. The Attorney General of the Federation needs to examine himself because his office has been somehow linked to this as well. I do not know if the presidency is directly involved in this, and I will not make frivolous charges. But high offices have been subverted in pursuit of a criminal purpose. I have committed no crime, done nothing wrong. If I have committed any wrong for which the state requires my attendance in a court or at a police station, they know exactly where I live. I will live only once, but I will not live cowering to any man. Let us be clear. If and when I have a charge to answer before a court, you all know where I live. I'm not hiding, and I'm not running away from anybody. Let us be very clear about that. I will never run away from Nigeria. We all have to pretend that we are in a democracy, and we have to pretend that we are citizens, and we have to pretend that we are a country ruled by law. And by all means, you will pretend that we are. I have done nothing. And if I have a charge that should be preferred against me, bring it on. I'm happy to come to court to have my day. If there is a crime, there must be justice, not only for the person who is aggrieved. There must be justice for the accused. And there must also be justice for the system. This is not how to build a rule-based system, where the system itself becomes so criminal that policemen were engaged in criminality.
He told us that. And just a quick one, okay? To some of you who like to be acting, should I say foolish or stupid? Yes, it is true. Dele Farotimi is a one Nigerianist, fine. But this is not the moment for you to possibly come and justify the injustice meted at him as we speak. Do you understand? So you can keep that to yourself, since you are not a one Nigerianist, okay? So we shall continue from where we last stopped reading this book. As we speak, we all have one common enemy, and that common enemy is the establishment that want to kill all of us, or is already killing us. And whenever we have a chance to take them to the cleaners, we shouldn't hold back. I mean, we all agreed, didn't we, that if all of us want to have our ways, the first thing first is to remove the stumbling block. Whether you want a Biafra, or you want to do a nation, or you want a Kwararapa, or maybe in Arewa you want, or even if now one Nigerianist you want to have, this current establishment has to go. Yeah? And until then, the only stumbling block to all of that is this one united contraption that is united against every one of us, that criminalized self-determination, that criminalized free speech, that criminalized free assembly. That is the enemy of the people. So whichever block you belong to, never forget this. You can't go it alone. Whether you want Yoruba nation or you want Biafra nation, or you want whatever, anything you want from that contraption, you cannot go it alone. The establishment is united. And that is why they turned all of our advocacy into criminality, so that they could have a reason to either kidnap us, jail us, and even kill us. So remember that we are fighting a common enemy, and that is the establishment that has no tribe, it has no ethnic, it has no religion. We are the ones that are sort of identifying ourselves as this, that. When it comes to the establishment, they do not have any loyalty to anything. They do not have any patriotism to anything than themselves. They are united. And that's why it is called class war. If Nigeria is to break, the first thing that needs to break is this corrupt, rigged establishment. And it is beyond just the politicians. That's why we have this book. The people responsible for that, that unfair system that you have in that contraption, those who are holding it together, they are not just politicians. You have your religious leaders, Christians, Muslims, and name it, right? You have those who are in the legal profession. You have those who are in the economic, in the banking profession. You have a lot of them in different areas, including community leaders, royal fathers, who are all in it together to keep us in this similar bondage of ruin, bondage of destruction. Nigeria. Never forget that. Brethren, if you have your book, I'm sorry if you just got yours, okay? And somehow, you have not read to the point. We are continuing from chapter 6, and that is page 35. Now, if you think I am going fast or too fast, you can easily just say, Mayego, slow it down, okay? I will do my best to make it very much interesting to listen to. And I implore you to please share this, okay? So let's go for it. Or should I give you a bit of a recap, right? Or, okay, I think let's go. Chapter 6, the practice. I always knew that I was going to strike out on my own after spending 2 years, learning as much as I could from everyone that I would work with. I don't know how I came to know this truth, but I knew it just as I had known the several other immutable truths of God concerning my life. I always felt his powerful compass directing my course and channeling my aspirations towards the achievement of my intended pursuit. I just knew. The conception of my first child coincided with the time my mother, who had been subsidizing my pupillage, had her own immigration problems and couldn't return to the land of her economic exile. It was also the time when the entire family was at its lowest level economically. I was, as I had mentioned, squatting in my friend's house, and I did not have any money saved up. But I knew that my daughter's conception was the trigger and that it was time. I made a friend that I have held dear since our days together at the law school in Buhari, Femi Adekeye. Femi was one of the foreign educated law school students. A lot of them were staying at what used to be either the guest chalets or staff quarters of the institution that used to house what became the Nigerian law school. This was sequel to Abacha's diktat that they be removed to Abuja, that his daughter, Gumsu, might safely attend law school from the family's compound in Aso Rock. I found Adekeye to be most unlike his fellow Buttrich fraternity. Now, we, the Okoko Bombers, as we called the caucus, we had formed during our undergraduate days at LASU, and which we had with the prime agency of our late brother, the effervescent and ebullient Obarinde Adeoba Ogunsoya, made inroads into the school administration's system. We had made friends amongst key persons and greased necessary palms. We were allotted rooms in the chalet and did not have to bear the pains of the guinea pigs that became the first occupants of the new and horribly constructed hostel accommodation. I met Femi at Chester Terrace. Femi had earned a first degree from the Ondo State University. It was anything but butter. He was at home, eating with us from the cholera joint located behind our block, and was equally at home amongst the coterie of assorted cheeses and dainties he became acquainted with in the years of studying law abroad. Femi, an all-round good man, and he was a key player in God's plan for my life. Femi went to work with the legal department of what was at the time Prudent Bank. Immediately after we had been called to the bar, and by the time that I was leaving KOT, Femi was a key factor in affording me the confidence to walk in faith. Prudent Bank was paying 2,000 naira to lawyers for the CAC searches that they were obliged to conduct as part of the KYC and due diligence requirements before they might open corporate accounts. And Femi had been faithful in giving these briefs to friends that had braved going into practice on their own earlier. The meager amount of 2,000 naira per search added up to a tidy sum when it came in a consistent flow, and many a Buhari inmate asked Femi to thank for sustenance in the early days of our law practices. I am eternally grateful to him. I had made the acquaintance of another fellow student at the law school in Buhari. I am unsure of how we might have met now, but Bola Hassan was a very jovial person and is imbued with a selflessness that is pretty rare in this climb. I had been running into Bola in courtrooms since we had left law school, and he appeared to be as much of a courtroom rat as I was. We would gravitate towards each other upon meeting up in court, but then that is a common issue with the first set in Buhari. We developed a bond forged in the furnace of our common affliction in Buhari. Bola's parents owned a commercial building on Sanusi Fakunwa, and Bola was running his law practice named Law Cartel with a K from a rather generous space at the rear of the building. When Bola became aware of my readiness to leave KOT, he made me an offer to join Law Cartel that I could not afford to turn down. I got the use of an office with an address in Victoria Island, a shared clerk, other facilities, and the offer couldn't have come from a nicer person. The arrangement allowed me to trade in my own name or under the Law Cartel banner, and all I had to do was to share the cost of running the office. I was happy with that. I was to remain with Law Cartel until just after my marriage and the birth of my daughter. I moved into the Kota complex in 2003/2004, and it was the beginning of the practice that I had sought to build. Rap Unwoke, it is that had serially provoked me into what I believe to be the closest I have ever come to defining my jurisprudence and outlining my legal viewpoints. Raf is a legal mechanic. He came to me as an associate in 2006, quickly gained my trust with his legal drafting skills and generally impressive intellectual capacity. He has a prodigious capacity for hard work that remains unmatched by anyone that I have ever employed. And it was for the years that I practiced with him, the professional yin to my irascible gang, or yang rather. Ra knows the law. He is a walking encyclopedia of law and one of the very best commercial law brains that I have ever had the privilege of either meeting or working with. He kept me out of trouble for years. If I have described Raf as a mechanic for his rigid insistence on fidelity with the letters of the law, I must admit that I was the artistic legal brain in the practice that I built. When strict adherence to the letters of the law would not be in my client's interests, and the law allowed the imaginative room within which to legally maneuver, I was always happy to take advantage of the room offered. I will be mulling over what I believe to be an ingenious solution to a client's legal challenges, and having doubts as to the lawlessness of the idea I had settled on. I will use Raf as the sounding board, luring him into the many passionate disputations that I enjoyed with him over the years. Thing is, Poor Rav assumed for several years that he was always just a step away from being fired for his constant audacity to argue with his boss. What he came to realize is that I was only ever grateful for his courage and looked forward to our sessions. It was during one of our heated sessions that I declared my philosophy of law, and I believe it was also the day that we began to understand the strength of our synergy and the value of efficiency. So, and the value and efficiency of our then emergent partnership. I explained to him that I did not read law in order to follow the rules. I read the law in order to guide myself and the purveyors of my services through the labyrinthine minefields of the Nigerian legal system. I always knew that Nigeria is built on a foundation of lies, that the country of my birth is iniquitous, unjust, and intricately evil. I had known this from my mother's womb, and I had never harbored any illusions about the existential nature of the evil empire in which we live. I explained how it was duty of the lawyer to work in the knowledge of this truth in everything that he does for the client. I explained how I relied on his own knowledge of the mechanics of the law to rein in my own worst instincts, which constantly seeks to discountenance the many inane laws and regulations that will restrain the client. Between our two extremes, the clients are usually left with the best of the two worlds. A client came to brief us about a property that the company owned in Ikoyi. Client is a property investment company that has a lot of real estate interest in the Ikoyi axis. The uniqueness of our legal architecture and tenancy laws had created an equally unique problems for them. Recalcitrant tenants that had learned how to exploit the institutional weaknesses of the legal system and the tenancy laws to game the company out of its legitimate business income and expectations. They would owe rent for several years and would happily pay a lawyer to delay the cases for recovery of the premises and the back rent. We put a stop to it. We crafted a clause that has become part and parcel of every tenancy agreement that we have drafted for that particular client. And anyone that has been happy to have the clause incorporated into their own leases that we have drafted, designed as it were for this particular client. I am happy to report it as one of the unique devices that we have employed in the services of our clients over the years. We introduced the re-entry clause into the tenancy lease agreements. The tenancy law have been drafted by men without any understanding of the need to protect the pecuniary interest of the landlord, and most certainly without any thoughts as to businesses that will be investing their capital in the real estate sector. The cumbersome laws and processes have served to prolong suit taken before the court seeking the eviction of debtor tenants, the recovery of the premises, and immense profits. Some lawyers have turned the delay tactics into an art form, and our clients were losing money. The government that has failed woefully in the business of social housing has drafted laws that are overprotective of the tenant's interests and dismissive of the property owner's right. We began to insert a clause that allows the landlord the right to re-enter the demised property upon the crystallization of a failure on the part of the tenant to meet the obligation to pay his rent. Ralph had argued strenuously against the inclusion of what he rightly identified as an unlawful clause, but after allowing him to make his point, I considered the legal soundness of his argument and then explained the legal basis of my decision to adopt the clause, in spite of his reasoned argument. A man that couldn't afford to pay his rent but would employ a lawyer to delay the recovery of the premises merely takes advantage of the system that has allowed the conditions favorable for his wicked refusal to meet his obligations. When a man has failed to pay his due rent, the very foundation of his occupation of the premises and the condition precedent to his peaceable enjoyment of the demised property will be hard-pressed to explain to the court as to why he should be deemed entitled to any monetary damages above the rent that he already owed. I have used the clause a grand total of 2 times, and none of the evicted debtors have ever managed to successfully sue my clients for damages. The only one that sued recalibrated his senses on receiving the counterclaims and defense to the suits that he filed. I have used this to illustrate the practical nature of the law practice that I built and the lack of any illusions in my engagement with the Nigerian legal system. I was not blind to the objective realities of my environment, and I happily evolved workable solutions to my clients' problems. I built what was to become a lean legal firm that, at its peak, was the biggest real estate law chamber in the country and remains accountable for the bulk of legal precedents used in the real estate industry in Nigeria to date. After the initial years spent essentially as a litigation lawyer, I quite deliberately and consciously avoided accepting litigation briefs. I had seen firsthand the extent of the rot in the court registry. I had seen the impossible caseload of the magistrates and judges. I could see that the judiciary is just as corrupt as any other sector of the Nigerian state. And I wanted nothing to do with the court system for as long as there was the likelihood of a negotiated settlement of the inevitable disputes that our clients ran into. The years spent watching Miami settling the Inolende squabbles became the bedrock of the firm's reputation for complicated business negotiations and disputes resolutions. We actively worked at all times with the deliberate intention of doing everything to avoid going to court. Litigation has always been a last resort in my practice, and from the very foundations, actively discouraged. As my practice evolved and my influence with my clients grew, I increasingly became the person that will provide the legal architecture for transactions from the initial beginnings. I found that the bulk of the arguments and disagreements on the draft would usually come not from the counsel representing the other parties, but from my own clients. When briefed to draw up an agreement, we would always draft blind. We are blind to the identity of the parties, and it would not matter a jot who was paying our bill. I had learned from Miami's feet that however happily a party might appear to concede an advantage whilst under any form of pressure, they would almost always regret the concession granted, and where and whenever possible, they would be looking to break the agreement. I had learned the most important part of any agreement is captured in the Yoruba doctrine of Ti ojuba ye oju, ki ohun koma ye ohun. Consensus ad idem. I have had countless disputations with my clients in defense of the initial draft of the several commercial agreements that we have drafted over the years, and I am happy to have been trusted with a lot of groundbreaking agreements in the real estate sector, which I spent the bulk of my legal career serving. Despite being the preeminent real estate law firm in the country, no legal document drafted by my law office has ever been invalidated by a court, and we have had less than 5 legal challenges to our clients' rights or interest arising from some legal error attributable to our work. I built a practice that knew the wisdom of avoiding Nigerian courts. As Mami was wanted to say, Ekiti called today, Kashore, no one comes out of a court case adjudicated in the favor of his opponent with a smiling face. Now, the beginning of the end, chapter 7. As I had said at the outset, I had always known that I would retire from the practice of law once I turned 50 years old. I never knew just exactly what I would be doing with my life thereafter, but I always knew, and I had never failed to communicate this knowledge to everyone that I considered my friend, long before I was called to the Nigerian bar. I had no concrete plans laid out for the remaining days of my life, but I knew I would be done with the earning my living from the practice of law, even when I was most in love with my profession. As the years rolled by, and I began to get closer to the appointed time for my exit from the practice, I began to think more and more about the future, and I sought to imagine and envision what laid ahead for me. Whilst it was easy to settle into the knowledge of my exit without agitating my mind over what would follow when I was in my 30s, the minute I rode into my 40s, I became more and more concerned about what laid ahead, just exactly what I would do with my life. I had been given the grace of value creation by my creator, and I was confident that I would always find buyers for the scarce values that I have been blessed to search out and to create. I needed not have worried. Eledumare had designed my path from the dawn of time. The day of appointment with my destiny was completely mundane in its dawning. It was the 26th day of May 2013. A Sunday it was. According to the calendar I consulted before commencing this chapter, and the date I had equally confirmed by checking the immigration stamp on my passport. The meeting was at the Heathrow Airport, Terminal 5. It was in the morning. I had traveled out of the country on the 18th of May 2013 to attend to some business in the UK. And as is the notorious case with me, I was in a hurry to return to our asylum. I have missed my flight only once in my life, and I missed the flight not because I got to the airport late, but because I mixed up the dates. I have earned my reputation for always being on time, and scheduled flights are not likely to be missed by me. I had gone through the BA counter, cleared the security checkpoints, and was in the lounge with about a couple of hours to spare, and having had a leisurely breakfast, elected to begin my journey to the departure gates. At the point before one might enter the lift to access the shuttle service, there are park benches arranged on either side of a wide aisle leading up to the lifts. And there, sitting on one, was the doyen of the Nigerian legal system, Afe Babanlaole. The old man had bags arranged around his feet. There was the usual carry-on luggage, and I believe 2 other leather bags. But there were a couple of plastic bags in addition. Baba had evidently been busy shopping at the duty-free shops. The Omo Oduagba that I am, I prostrated like a proper Inolende boy, greeted the old man, and offered my services in carrying his baggage. He gratefully declined, and when I insisted on account of my concern for how he intended to carry so much on his own, he let on that he had helped and was only waiting for some other persons or persons. I bade him farewell and took my leave. Little did I know of the significance of the moment. I usually know, but this time I did not know. The first we knew of the magic being put together by Afe and his elves must have been around the middle of July, probably a couple of days after the Supreme Court delivered its original judgment on the case. The aborigines of the Ajiran or Sakwa axis were whispering about the Ojomu's loss of the case at the Supreme Court. And this was followed by very aggressive moves by the Eletus themselves. Signboards began to appear all over Osakwa, Agungi, part of Nikon Igbokusu, Victoria Park, Friends Colony, and the Pinnock Beach Estates. They were asserting claims to 254 hectares of land, and several clients had called me up in panic. In introducing myself, Chief Afe Babanlaole described himself as solicitor to the Gbadamoshi Eletu family. And indeed, the family were the appellants in the case. But the question is this: who and what is the Gbadamoshi Eletu family? Who is Gbadamoshi Eletu? This becomes important given the fact that it is the basis of engagement with Chief Afe Babanlaole, and it is also the point of engagement between the courts and those who claimed rights on the land on behalf of the Gbadamoshi Eletu family. There is no entity known as the Gbadamoshi Bamidele Eletu chieftaincy family. It is a creation of fraud, and nothing can be found on a claim arising from a fraud. Legends have it, and facts have proven so, that a certain man by the name Major Eletu purportedly purchased 254 hectares of land from the Ojomu chieftaincy family, and to whom title was conveyed by a deed of conveyance in 1977. Duly registered at the land registry at Alausa. Any and all successors to his title, actual or imagined or contrived, as in this case, must claim solely from these roots. The deed of conveyance is one of the many titles determined by the Gazette of Acquisition of 1993. This was the acquisition, this was the acquisition that was challenged by the Eletus in M/779/93. That was the claim that was definitely settled in the case. This is the case that Justice Akas adopted in the first judgment of the Supreme Court. Upon the death of Mr. Gbadamoshi Eletu, no probate records have been placed before any court. No will, nothing to indicate what happened to the estate of Mr. Gbadamoshi Eletu. However, those who have presumed to claim land in his name have acted at all times, placing the deed of conveyance of 1977 before the court. These persons might be related to the owner of the land conveyed by the 1977 deed, or they may not be. But as the facts reveal, there is no family in the sense in which the word family is used within the Lagos State Land tenure system. There is no Gbadamoshi Eletu family. I reassured all that any claims by the Eletu to anything more than the 10 acres granted to the Eletu in suit number M/779/93 can only be made in fraud. And I was categorical in concluding that even a Supreme Court bench, wholly staffed by their ancestors, was incapable of giving them the relief that they claimed to have won. I knew this because I had been following the case since the beginning of my law practice and during my time at Bassa and Partners. I immediately contacted our representatives in Abuja to make the necessary application to the registry of the Supreme Court for the CTC of the judgment and the enrolled orders of the courts, and same were procured within a couple of days. It is amazing how efficient the inefficient registries could become once the process is sufficiently greased. I mean, a cursory reading of Justice Aka's lead judgment was enough to show that the Eletus were up to some shenanigans, and the roots of their mischief became apparent soon enough. Upon studying the judgment itself, in the face of the intransigence of the Eletu family and their continuing refusal to respect the boundaries of the judgment that had been given in their favor, it became incumbent upon us to seek to speak with the Afe Babanlaole firm and the Eletu family themselves. We wrote a series of letters, both to Oludaramola San, as the head of the Afe Babanlaole chambers in Lagos, and also to Gbadamoshi Eletu family, specifically Chief Wahid Eletu, and sought to hold meetings with them in order to better understand the parameters of any disagreements or disputes that we might have with them, whilst we continue to monitor what was going on. We had by this time become aware that the head judge in Lagos State, Atilade J, had signed a writ of possession. Being made aware of this, we continued to write letters to the sheriff section and to the Chief Justice, including concerned authorities, to make them aware that this will be acting beyond the judgment of the court, as this will be at variance with the claims that the parties themselves had placed before the court at all material times, including before the Supreme Court. Whilst all this was going on, we had a meeting in the law office of Afe Babanlaole in Magodo, where Oludaramola San made himself unavailable and had us meet with Olufaro, a younger counsel. I have always treated counsel differently, and I have been particularly respectful of senior counsel. Every counsel that has worked with me would attest to my demand that respect for colleagues be primary. But Olufaro Esquire was remarkably insolent and assured that we were made aware of just how powerful the law office he worked for believed himself to be, and how much above the law and the practice of law they believed themselves to be. The meeting achieved nothing. The judgment of the court was unanimous in giving judgment to the Eletus, and the pronouncement of Akas were clear and unambiguous. The Eletus were entitled to the compensation that they had been awarded for their land in case M/779/93. But Justice Rodvival laid the foundation for the fraud that was to come. He spoke of an unextinguished equitable interest in 254 hectares. It is my contention that he was not serving the cause of justice when he made that pronouncement, and he was aware of the mischief intended with his deliberate choice of words. With the Eletu's aggressive assertion of the claims that they were awarded 254 hectares gaining traction in the press, and their seizure of several plots of land from small landowners in the Agungi-Osakwa axis, my office became inundated with calls from dispossessed owners, land buyers from the Ojomu family, and developers of all hues, big and small. The panic engendered by the actions of the Eletus bred mass hysteria, and through it all, we kept advising our clients to stay firm and to refuse to succumb to the blackmail of the Eletus. I had seen enough by the end of September 2013 to be convinced that there was a high-level conspiracy involving elements in the Supreme Court, Lagos Judiciary, Afe Babanlaole and his crew, and with the Eletus as co-beneficiary. On the 7th of October 2013, I got news early in the day of an impending invasion of the Osakwa Agungi axis by the Eletus and their lawyers, accompanied by thugs and police, supposedly on a mission to enforce the Supreme Court judgment. I immediately placed a call to Oludaramola San and asked what judgment he was planning to execute on my clients, and reiterated the readiness of my clients to engage with his firm to determine how the judgment might affect our clients. He denied any knowledge of any planned enforcement actions, assured me that nothing of sort was afoot, and agreed to have a meeting with me on his return to the country from a trip he disclosed that he was poised to embark on. That same afternoon, as I was poised to commence the usual Friday afternoon lunch in the office, the call I had dreaded for weeks came through. The Eletus were on their way to the neighborhood with the full complement of the Nigerian state, its power and majesty, violently violate the human and property rights of the inhabitants of the vast swath of land that run from Nikon Town to Victoria Park, French Colony to Pinnock Beach Estates. Several small landowners and built-up properties were being directly threatened. My heart broke. As I have let on, I am no shrinking violet. I'm a Nigerian in the true sense of the word. I am no saint. I have never had any illusion about the country of my birth. I have known and loved the country of my birth and residence all of my life. But it has frustrated me unrelentingly, and I have hated it for the many times that it had left me bruised and broken. I had always had a rather romantic view of the law. I imagined that the Nigerian Supreme Court was somehow immune to the madness. I lost my illusion that day. The electors were accompanied by bailiffs and sheriffs of the Lagos High Court. The Nigerian police were represented, and the Nigerian state was assisted in the rape of its citizens' rights by a land of thugs, led by the younger of the Eletu clan. I called Oludaramola as they approached the place where I had stood with some clients to resist the illegal enforcement, and the shameless man was still busy denying any knowledge of the enforcement action. We were partially successful in resisting the enforcement. The bailiffs could not produce the enrollment of the order that they sought to enforce and departed the scene after writing some nonsense on the wall. We immediately applied for the certified true copies of the processes filed with the sheriffs, and it quickly became evident what mischief was afoot and just how deep the fraud and conspiracy were. The warrant of execution was signed by Atilade J, the administrative head of Lagos Division of the High Court, without her having seen an enrolled order of the Supreme Court. Let me remind you, the bone of contention here is that Afe Babanlaole and his gang, right, they forged a Supreme Court judgment for a family that has no right to a land in Lagos. That's criminal, isn't it? We are going to get to that part too. The family that owns the land in Lagos, they were taken to court. And upon being taken to court, they won their cases. But surprisingly, when they got to the Supreme Court, which was when they hired Afe Babanlaole, when they got to the Supreme Court, it was also pronounced that they did not have any right to the land. But somehow, they can take a certain number of the land as like sharing the land. Supreme Court decided to say, okay, we don't want you to come here empty-handed. Okay? These 254 hectares of land is not yours. But you know what? We'll give you 10 from that land. You can take 10. You, the owner of these 254 hectares of land, you know something? Give them 10 now. So when that judgment came and it was time for them to execute it, right? Afe Babanlaole and his gang, they forged the Supreme Court judgment that instead of taking 10 hectares that the Supreme Court dashed them, they decided they would take all the lands, 254 hectares. Here you get. So this is why Dele Farotimi is like asking, can you give us a certified true copy of that judgment? But it has been altered. This is where the role of Afe Babanlaole and his chamber, this is where it comes in. They forged the judgment and they gave themselves the right to claim all the lands. So when the true copy of the judgment arrived, it gets worse. Let's continue. The more we scrutinize the writ of possession, the more apparent the fraudulence of his procurers, issuers, and beneficiaries became. It became patently clear that the head judge in Lagos, Atilade, had either wittingly or unwittingly lent herself as an instrument of fraudulence in the issuance of the writ of possession that they presumed to execute on the 7th of October, 2013. One of the first things that we found most incongruous was the complete absence of the enrolled order of the Supreme Court in the processes. At no point did the judge, Atilade, or the sheriff cite an enrolled order of the Supreme Court. What was done was that a portion of the consenting judgment of Rhodes Viver JSC, as he then was underlined. And this was the portion that spoke of an extinguished equitable interest in 254 hectares. I am persuaded to conclude that this obiter was inserted specifically for the purpose to which it was pressed. Nevertheless, this was all that was before Atilade, the head judge of the Lagos Division, where she issued a writ of possession covering 254 hectares. Another curious thing we found on perusing the execution file was the presence of a most fraudulent person by the name of S.B. Joseph San, who was the procurer-in-chief of the writ of possession issued by Atilade J, and was in actual fact the one who worked exclusively at all times on the procurement of the fraudulent writs of possession. We quickly realized that the law offices of Afe Babanlaole and C and Co, Emmanuel Chambers, had outsourced the judgment execution to another law office, the firm of S.B. Joseph and Co. The firm had fraudulently and deliberately concealed the judgments of ACAS and had underlined the words of Justice Rodviver to deceive and perhaps mislead Atilade, or as is more likely, Atilade was always a part of the original fraud. The Eletus somehow managed to corrupt the judiciary to procure a fraudulent warrant that had no bearing on the judgment of the court. On being convinced of the emerging fraud, I made strenuous efforts to protect my clients from the extortionist exercises of the Eletus and their lawyers. I wrote several petitions to the fraud unit at Kwanti, CID, another to the Chief Judge in Lagos State, Ayotunde Phillips, the National Judicial Commission, and yet another was addressed to the Attorney General of Lagos State at the time, Mr. Ade Ikpaye. I also ensured that one went to the governor of the state, BRF, Fashola, who, being a lawyer, I imagined, would be better briefed to do the right thing related to the issue, given the likelihood of a breakdown of law and order, and in view of the fact that the Eletu, in seeking to enforce the fraudulent warrant, had invaded multiple estates within the Lekki, Ajiran, or Sakwa axis, pursuant to the fraudulent writ of possession. I imagined that the case would be of interest to the governor, given his legal background, and it was equally copied in the petitions. I detailed the duties of the state to protect the integrity of his own title, and generally made all aware that I was not only aware of the fraud, I was prepared to blow the whistle on all that were involved. BRF was not interested enough to do anything decisive about the obvious fraud and brigandage. He passed the buck to the Attorney General, Ikpaye, Akim Okunla, then the Permanent Secretary, Lands, and Agbenla, the Surveyor General. When the heat I was drawing became a little too much for the head judge, Atilade, he reached out through one of the clients and the Ojomu Shiftansi family, seeking to explain that she was misled and had made a mistake. I was informed of her regrets at what was termed inadvertent error in signing the warrant. Atilade was at the time in the pivotal place of waiting in the wings to succeed her sister as the Chief Judge of Lagos State. She was interested in doing everything she could to douse the fire that had been kindled by her participation in the issuance of the fraudulent writ of possession. She pleaded with them to appeal to me to bring a motion to quash the warrant that she had originally issued for the possession of 254 hectares. We prepared the motion to quash the warrant after sending same to our client for execution. The client returned to us, obviously, having coordinated with the judge who begged, saying that instead of the ground stated in our motion, which was for fraudulent misrepresentation, we should have it changed and request that it is quashed for documentary irregularity. The original motion prepared by my office was a motion on notice. We prepared this and readied our processes to be filed. Then word came to us by the Ojomu's Palace Atilade had asked that we file the motion ex parte. This was to avoid a lengthy delay. She assured our messengers to me, as having the motion paper served on Afe Babanlaole and co, we only serve to prolong the resolution of the problems created, either by our corruption and or incompetence. My reasoned arguments against the ex parte motion were not countenanced by the clients. They all just wanted the mess over and done with. Multi-billion naira investments were being undermined by the situation, and several lives were being disrupted, they argued. In deference to the client's instruction and urging, and in clear refusal of our legal advice to the client, that the matter should not be withdrawn, but argued on its merit as being sought for fraudulent misrepresentation, we were prevailed upon to present a motion ex parte, asking for the warrant to be quashed on the ground of documentary irregularity, a euphemism for fraudulence. We followed the client's wishes in protest, but we were convinced that something wasn't quite right. Events were to prove us right. The motion was filed ex parte, as had been advised, and Atilade heard the motion in chamber on the 11th October 2013, quashing the fraudulently procured warrant as promised, and euphemistically referring to the ground as being one of documentary irregularity. But even as Atilade played the contrition game, she was already part of the game plan being stitched together by the Grand Master of Judicial Corruption in Nigeria, Afe Babanlaole. I have come to the conclusion that the required form of the application and our ruling were all part of the insidious plans of Afe Babanlaole, his band of crooked lawyers, and the coterie of crooked, incompetent justices of the Supreme Courts. I will take a break. It's called tea break, right? I'll be back in a minute.
I am conscious of exactly what kind of country I live in. But it used to be my belief that as crazy as we might be, that there is still something that must undergird our system. And that is the sanctity of law. I used to believe that even if the High Court judges maybe a few might be corrupt, and I knew a few who were. Maybe one or two Court of Appeal justices might be amenable to pressure, but I never believed that an entire system would be subverted in pursuance of narrow interest until 2013. But I'll let the book speak for itself. But it is of critical importance that this book be written, and I will explain why. I worry about the society that we have built, that we are building, and that we are likely to bequeath to the next generation. I have tried my best to be faithful to the truth. I have allowed the truth to be the sole bridle for my pen, and I have written believing in the complete truthfulness of each and every word that I have put in that book. But the truth needs to be told. So what I have done for my children. I have done for my conscience. I have done my own bit. Let them do their own bit. Hopefully they find the grace to adhere to the rule of law. Thank you very much.
Rule of law or rule of money. Chapter 8, the purchased judgment. The Agbenla Alausa conspiracy, chieftaincy family. The battle to quash the warrant opened my eyes to the extent of the rot in the court systems, and I came to the knowledge of the sickening realities of the systemic putrefaction. The Supreme Court's judgment was doctored by the Confederation of Lawyers in Afe Babanlaole's chamber and the law offices of S.B. Joseph and Co. And the end desired by the Confederacy was sought with the active connivance of head judge of the Lagos Division, Atilade. I submitted a petition to the police and I soon found that the Eletus and their crooked lawyers had co-opted the police into the scheme. The Eletus managed to move the sheriffs and bailiffs to execute the doctored judgment, and they did this in spite of the fact that I had placed all of the relevant authorities on notice and had drawn the attention of the Chief Judge of Lagos State and the Attorney General to the fraud. Drawing pointed inferences to the legal incongruity of having the judgments applied to people whose title to their properties are rooted in the government's own grants to the Ojomu by the Gazette of Excision, and in the case of Nikon Town, to peoples outside the customary jurisdiction of the Ojomu family. In the immediate aftermath of the court order quashing the fraudulent warrants, the Eletus continued to strong-arm the small plot holders outside of the bigger holdings that had mostly lawyered up and joined in the battle against the Eletus onslaughts. Seeing as the Eletus were undaunted by the order quashing the fraudulently procured warrants, we were left with little or no choice but to fight back in protection of our clients. We applied to the then Surveyor General of Lagos State, Agbenla, to produce a composite survey of the land in dispute. Agbenla was the Surveyor General of Lagos State at the time of the delivery of the Supreme Court judgment, and given the tip I had been offered by Mr. Osan Idemudia about the survey fraud in the Eletus deed of conveyance, I deemed the commission of the composite survey to be of extreme importance. But I had another reason for wanting the Surveyor General's composite, one that is rooted in the oral tradition of the Ojomo people and of that of their neighbor to the east, the Elegushi. From the dawn of ages and from the oral account of the two traditional land-owning families, the Ojomu and the Elegushi have for generations considered the Mayegun Creek, now known as the Mayegun Canal, as their traditional boundary. The village of Osakpa, one of the Ojomu's villages, is to one side of the canal, and Igbokushu, one of the Legushi's villages, is on the other side of the canal. The Ojomu is the consenting authority for the Baale stool of Osakpa, and the Elegushi is the consenting authority for the stool of Igbokushu. Nikon Town is located inside Elegushi's Igbokushu village. I know this because I had worked for Basa and Partners and Oyekon Abdullahi. She was the lawyer to the Igbokushu community when they sued the Elegushi to challenge his right to sell the land that has today become known as Nikon Town. How did the Ojomu come to sell land to Gbadamoshi Eletu beyond the clear boundaries of their own land? Remember how I had been integrated into the Ojomu family by my early associations with the young princesses? Well, they might have introduced me, but I had become part of the fabric of the Ajiran community, lived amongst the natives and befriended them with integrity and honesty. They told me their war stories as we shared life's experiences. One of the stories that more elderly ones never appeared tired of sharing was the story of how they were defrauded, cheated, and exploited by Major Bamidele Gbadamoshi Eletu. The older generation would tell of how the affluent member of the Eletu Odibo, chieftaincy family of Lagos Island, a family to which several prominent Ajiran families are equally related, was granted land on which to settle at Osakpa, and how they subsequently sold him a vast parcel of land. Their bugbear was that the survey, which he was to subsequently attach to the deed of conveyance, which they signed as illiterates, exaggerated the extent of the land sold. They were universally bitter, and I never forgot their stories. The judgment brought back the memories, and the attempt to extend the judgment to Nikon Town was sufficient enough to warrant the need for the composite survey, even if I did not have the benefit of Osahon's tip. I had made the original application for the composite very early in the day. It was made within weeks of the judgment, and as part of the immediate response in the wake of the aggressive claim of the Eletu. Once the Supreme Court's judgment was delivered, Now, you have to understand that in the course of my legal practice, I had built up a vast network of contacts within the Lagos State Civil Service. 12 years of my life spent in Okokomaiko had assured that I have never entered a civil service establishment in Lagos State and failed to find a LASU brother or sister. The survey department was not an exception. I have handled thousands of governor's consent applications in the course of my law practice, and the survey department is fundamental and critical in anything that one might seek to do in Lagos State that is related to land or any real estate. I have informal channels to plug into any quest requiring governmental involvement, however tangential, and the survey department was not an exception. Even as I awaited Agbenla's execution of the composite survey report, and whilst it took months before same was received from his office, I had received unofficial confirmation, and Agbenla's survey proved to be quite interesting. The land described by the survey in the registered conveyance route of the Eletus fraud is tens of kilometers away from the Lekki Peninsula. It is in Badagry. Now, to be sure, that report merely confirmed what I had been told by Osan Idemudia, who had taken a case against the Eletus a couple of years before and had discovered the survey discrepancies when he sought to ascertain their claims on his clients by having a composite plan drawn. The Eletus and their lawyers abandoned their suits when the composite was filed in court. As a mountain of evidence improved of the Eletus fraud began to pile up, and in view of the order that Atilade had granted quashing the fraudulent warrant that she had issued, and as Afe came to realize how useless the original judgment had become, Afe went back to the accomplices at the Supreme Court. And this is the only logical explanation for the shameless and brazen review of the fraudulent judgment by the second sitting of the court, where the justices destroyed whatever doubt one might have harbored of either their corruption and or incompetence. It was around this time that we began to hear rumors of a return to the Supreme Court by Afe Babanlaole and his magical elves. And the rumors became real when I got a call from Tokunbo Williams' son, who informed me of the receipt of a motion on notice before the Supreme Court, seeking to correct an error in the judgment produced below. This application to correct errors was brought under Order 8, Rule 16 of the Supreme Court of Nigeria rules, which provides as follows. Let me explain that. The Ojomu family, the owner of the land in question or in dispute, and then the Badamasi Eletu family, the fraudsters who conspired to steal their lands. When they went to Supreme Court the first time, the Supreme Court ruled, right, that they should be given 10 hectares of land. It was the Elegushis, according to this book, it was the Elegushis that sold land to the Badamasi Eletu. However, the land that the Eletus are claiming to be their own is the land that belongs to the Ojomu family. So the Eletu family have the boundary where their land, the border, they say, okay, this is where your land stops. So how could somebody from this side sell lands from this side? So the only way they could do it is to get the corrupt judiciary and then some other people involved. So when they went to the Supreme Court said no, 254 hectares of land with all this evidence were not sold to, there's no record that Ojomu family sold land to Eletu. It was the Elegushi that sold land, and their land did not cross this path to this path. But because Afe Babanlaole is involved, we'll give you 10 hectares, not all these things you want to claim. So immediately they came from that court. Afe Babanlaole and his lawyers, they doctored the judgment. When they doctored the judgment, the Supreme Court judgment. They now went to the Chief Judge of Lagos State, Atilade, to help to issue a possession writ, a possession warrant, which is that the Supreme Court has ruled that the whole 254 hectares of land belong to us, and now we want to take the land. Upon realizing that the judgment was fraudulent, was doctored, all the petitions of Dele Farotimi to the police, normally they should have had Afe Babanlaole, the other one, Joseph Chamber, they should have had them arrested, but they were not arrested, right? Those who should act on it, they sat on it. So when they realized that it was going to be a big mess, Atilade advised Dele Farotimi to file an ex parte order. An ex parte order to quash, that is to cancel the warrant that she issued for the Afe Babanlaole's, the Eletus, to go and claim the land that is not their own. To save her head, right? She said, don't make it a case. Make it an ex parte order. Ex parte order means Afe Babanlaole and co, they don't have to appear, you know? So, and despite the advice of Dele Farotimi, that to the Ojomo families, that no, let us actually really face it and face this guy and expose this their fraud. Don't use ex parte. They said, no, this whole wahala is delaying multi-billion naira investment in this land. So let's just kind of like do what the judge advised. So what did Afe Babanlaole do? Using his power, he went back to the Supreme Court, okay, and asked them to review the judgments that they gave. The judgment they've already issued, though, that they should review it. So upon reviewing that judgment, what happened? The Supreme Court now ruled that the 254 hectares of land should be given to Afe Babanlaole's clients, the Eletus. That is the bone of contention. Let's continue. The application to correct errors was brought under, that is them, legitimizing the fraud perpetuated by Afe Babanlaole and all that are involved. He used this influence, his corrupt ways, to get the Supreme Court to say, oh, let's use under the Supreme Court rule, right? Change it and yeah. Nigeria Judiciary. This application to correct errors was brought under Order 8, Rule 16 of the Supreme Court of Nigeria Rules, which provides as follows. The court shall not review any judgment once given and delivered by it, save to correct any clerical mistake or some errors arising from any accidental slip or omission, or to vary the judgment or order to give effect to its meaning or intention. A judgment or order shall not be varied when it correctly represents what the court decided, nor shall the operative and substantive part of it be varied and a different form substituted. However, Rule 18, ruling of 18th March 2014 was not done to correct any clerical mistake or some errors arising from any accidental slip or omission. Nor did it vary the judgment or order to give effect to its meaning or intention. What the Supreme Court did was to simply sit in appeal over its judgment and give a new judgment. It is pertinent to note that the judgment of the Supreme Court on 12 July 2013 was fully supported by the reasoning of the Supreme Court, as fully adumbrated by ACAS, JSC, who read the lead judgment of the Supreme Court. A portion of the judgment stated as follows. The appellants are entitled to the statutory right of occupancy over 10 acres which is approximately 24.17 acres of reclaimed land in Osakpa village, which has been excised and assigned to them. That was the judgment of 12th of July 2013. Therefore, the court intended to make an order awarding 10 hectares to Eletus and not 216.758 acres, which the Supreme Court curiously awarded in its second judgment on 12th of March 2014. Even if the reasoning of the Supreme Court was wrong, the court does not enjoy the pleasure of revisiting its reasoning. Parties are doomed to live with its consequences. I found this second visit to the Supreme Court alarming and strange. In our review of the case and considered professional opinion, the Supreme Court had become functus officio and could not revisit the matter, given that we had conclusively dealt with the conspiracy. But apparently, we had underestimated the extent of the putrefaction of the Supreme Court and the extent of Chief Afe Babanlola's corrupt riches into the innards of the Supreme Court. It was at this time that we had occasion to begin to liaise with the law firm of F.R.A. Williams & Co., and more particularly with Tokunbo Williams, son, who had charge of the matter on behalf of the Ojomu chieftaincy family. In the course of our interface with the chamber, we became seized of the full file of the case in M779/93, where Rotimi Williams' son had a watching brief and the extent of compromise that had taken place within the Lagos State Judicial Civil Service, particularly the Ministry of Justice, where persons who had been involved in the defense of M779 had become principal officers today. We have good reasons to believe that Roadvival JSC was one of the counsels involved, either directly or tangentially in the case between LSDPC and Aris Dredging. Major Muritala Gbadamosi, later retired, ORS versus Attorney General of Lagos State, ORS, M/779/93. The quashing warrant of execution became the basis for Afe Babanlola's latest excursion to the Supreme Court, and the error of my acceptance of the corrupt offer of an ex parte application to quash the warrant for documentary irregularity became obvious to me. I knew before the motion was heard that the court was working to the conclusion desired by Afe Babanlola. In spite of the spirited attempt of T.E. Williams' son and Boma Alabi, son, who appeared on behalf of UPDC before the Supreme Court headed by the current CJN, Kayode Ariwola, shamelessly proceeded to turn themselves into surveyors and mathematicians, ruling on a claim that was never placed before any of the lower courts, and one that was certainly never in the contemplation of a court that was not seized of jurisdiction. The Supreme Court, in a most shameless manner, sat a second time on the same matter and established the facts of the incompetence or corruption of each and every member of those who were involved with the Gbadamosi Eletu case, save and except Akas, now retired, who read the original lead judgment and correctly awarded the Eletus the 10 hectares they had already been granted in M779/93. This was the point where I realized that the Nigerian judiciary was hopelessly lost from top to bottom. The Eletus claim had been so thoroughly discredited by the work we had done in Lagos that by the time the second judgment of the Supreme Court was given, the Supreme Court had practically lost all credibility or legitimacy as it relates to any judgment given outside the one originally read by Justice Akas. At this point, there was a stalemate. The judgment of the Supreme Court, which known to all legal practitioners who had bothered to read the judgment saw that the files and records made no sense. Despite this, there was official complicity on the part of several officers of Lagos State government and the judiciary, beginning with the head judge Atilade to the deputy sheriff of the High Court, and most likely the chief judge herself. Hence, the situation was that the totality of the Supreme Court judgment was in itself very contradictory, as to become useless before the Lagos State judiciary and Lagos State government itself. We had established that the land claimed by Eletus was different from the one described in their deed. Let me explain that too. Like, after getting the judgment, right, it's like you take a case to Supreme Court. And then by the time these guys made their ruling, right, their ruling is even in contradiction, okay, of the case that these guys even took to the Supreme Court. It's like there's so much like contradiction in the whole thing. The land is like me saying, my land, oh, this land here is our own. And we're supposed to be, say, okay, how many hectares is that? Oh, it's going to be 10 acres. So you take 10 hectares, so you take it. 27 acres of land. Okay, take that. Then you turn around and you're like, okay, this new judgment says, because they doctored it, right? The new judgment now says, oh, you don't have to take 10 hectares. Take 216. Yeah, take everything. But there is no Lagos State government document in the lands or what have you that has Eletus' name, okay, on any of this Supreme Court ruling. Like, correspond. How we go take? So, does that mean that we have to start changing names on some documents now so that they can be able to claim this land that Supreme Court has given to them? But it is Nigeria. So we had established that the land claimed by the Eletus was different from the one described in their deed. We had also worked to show very clearly that the judgment in question was a declaratory judgment that was not in any way capable of enforcement in the manner that the Eletu and their lawyers had sought. The Nigerian Supreme Court on the 18th of March 2014, in a most shameless and profane judgment, pronounced itself functus official and had in shutting out the several parties that would be affected by the sickly miscarriage of justice to which it had yoked itself, given Afe Babanlaole and the Eletus judgment on arrests, over which it should have declined jurisdiction. In view of the plethora of reasons already before the court, that would show that the Lagos State government was a necessary party if the court was to ever assume jurisdiction over the 254 hectares. The miscarriage of justice may only ever be explained by corruption of the most nauseating fashion or intellectual indolence of the most criminal type, given the sacred finality of their pronouncements and the weight of the office that they occupy. The problem for Afe Babanlaole and the Eletus Confederacy was the unyielding force that my firm became in the several petitions that we had written to place the Lagos State government on notice of its obligations to defend the title of the several clients who had relied on the Lagos State Gazette of accession to the Ojomu Chieftaincy family via the existence of suit number M799/93. Major Muritala Badamoshi Eletu retired versus Attorney General of Lagos State. Case number M/779/93. The incontrovertible and clear fact that there was no cover for the issuance of a warrant for the 214 hectares rendered the judgment useless and changed the power dynamic in the conspiracy and amongst the co-conspirators. With the comprehensive destruction of the legal basis of the procured judgment, the Lagos end of the conspiracy that had the law firm of S.B. Joseph & Co. at its head, Itato, the junior partner in the conspiracy, fulfilled his role, began to deliver the execution content of the conspiracy once Afe Babanlaole had perfected the Supreme Court end of the job. These plans were made without factoring in the X variable, a law firm that saw through the fraud and shenanigans, and counsel who just would not let go of the injustice. With SB Joseph rendered incapable of delivering on his brief, and Afe Babanlaole unable to move the Chief Judge of Lagos State, and by extension, Lagos Judiciary to issue a warrant of execution of the fraudulent judgment, as evidenced by the letter dated the 20th day of May 2014, which formed part of the exhibit annex to Afe's claims against Pedro, and is the basis of the suit that I filed against Chief Afe Babanlaole in suit number LD/2787 GCMW/2016, Dele Farotimi versus Afe Babanlaole. The Lagos crowd had been snookered into a corner by the exaction of my chambers, and we had demolished the original fraud that was arched before Afe secured the first of the two judgments. I have known of the Eletu family since the beginning of my legal practice. I know as a fact that the entirety of their claim is founded on easily established and incurable fraudulence. The Supreme Court cannot hide behind the incompetence of counsel, as it has a duty to examine its own appalling intellectual indolence, corruption, or incompetence. The facts of the Gazette of Acquisition were before the court. The existence of the clear and inescapable judicial estoppel that would operate to stop the court from assuming jurisdiction on anything beyond 10 hectares was also before it. But the court, as though enthralled by whatever Afe and Circus Master had promised the justices, acted with utmost carelessness about the integrity of the court, the interest of the citizens, and the state that they had been sworn to protect. The conspiracy was always a step ahead of us because some of the clients mistook key members of the Confederacy for friends and helpers. In the immediate aftermath of the second Supreme Court judgment, a stalemate arose about the enforcement and perhaps enforceability of the judgment. We had provided copious reasons to the judicial authorities in Lagos. The Attorney General had been dragged into the matter. The brutal attempt at enforcement of the original judgment against organized estates and corporate establishments had served to galvanize extremely critical and sensitive mass of the affected peoples. And this was when Afe Babanlaole lost his influence on the Eletus and the Lagos Mafia, whose original brief to procure enforcement of the judgment became the dominant force in the conspiracy, muzzling out the Afe gang. With Afe Babanlaole rendered impotent, Lawal Pedro muzzled in on the kill. I'll take another short break. Again, this is like my own tea break. Then we're going to go to chapter 9, Pedro and the Jackal, before we wrap it up. We have almost finished reading this.
The law is an ass. They say the magistrate or the court has the discretion on bail. The matter is a bailable offense. Yes. As of today, they are saying arguing on bail, which is, for me, wrong. Very, very wrong. I expected that he should be granted bail because, yes, the prison custody is not built for animals, but it is built for felons. And when it is the law that will decide who the felon is. You don't judge and decide who the felon is when you have not even had a substantive matter. And that is why at this preliminary stage, you don't expect the court to jump into the arena. The fact that the court didn't give him bail is wrong. The High Court had given him bail. The Federal High Court in Ekiti gave him bail. They took him to Federal High Court. Now they had another one is springing up in Abuja, but I guess that one is a civil matter. The one in Ibadan is also a civil matter because they came by writ of summons. The one in the magistrate court, obviously, that magistrate cannot, in all honesty, say that he is acting out of his own self-will. He cannot. Because if he does, there's no reason why he will not give him bail. At least give him bail, and then when he perfect his bail condition, he will now come to answer for all the issues. The issue of whether it is a criminal defamation or not, and whether it exists in Ekiti or not, is yet to be fine-tuned. Because I've had one former Attorney General of Ekiti State that says that, yes, the law of Ekiti still recognizes that there's criminal defamation. And everybody will now begin to quote, yes.
Check the laws of 2021. I have empirical proof here. I read through it. It doesn't recognize criminal defamation. It only talks about section 70,
which
where there's a breach of public place through publication.
Through publication. Good. A breach of public peace through defamation.
Yeah.
Which
no, not through defamation.
No, through publication, sorry.
So that's not criminal defamation.
Through publication, which, of course, is relying on the Criminal Code Act.
Criminal defamation was not
all right. Relying on Criminal Code Act, and it was integrated by Ekiti. I mean, by Ekiti State in that 2011 laws of Ekiti State of Nigeria, 2012.
No,
that
2012.
There was that one. I am not arguing whether it is still there.
Voila everywhere, man. But you know what? Let's wrap it up. Okay, let's go to chapter 9, which happened to be the last chapter. Lawal Pedro the Jackal. Lawal Pedro lent himself as a negotiator and became a broker between those the Eletu were seeking to assert their judgment against and the judgment debtors. He began to play a double game. In one breath, he would assure the affected persons that he was seeking to find peace. And in another breath, he was assuring the Eletus that he would be able to find them some sort of settlement. He held himself out as the solution to the problems of both the litigants and those affected by the judgment. He inserted himself into the situation and became a factor for the Eletus and their victims. In the midst of this, Oyekun Abdullahi, who had been connected to the Ojomu family long before I was called to the bar, and who still enjoyed a chummy relationship with the Kabiyesi and the Balogun, and who was equally friendly with some of my clients, was busy undermining the client's confidence in my capacity to do my job as a lawyer, erroneously advising them that the Supreme Court judgment remained valid and that they should consider negotiating a settlement with the Eletus. I had a situation where the Solicitor General of Lagos State was advising my client to discount my legal advice because he was interested in brokering deals between my clients and the Eletus, who he knew or should have known had a fraudulent claim at best. Oyekun Abdullahi, on the other hand, was largely motivated, perhaps, not only by money, but also by personal relationships that had gone sour. He did everything under the sun to make sure that my client did not have confidence in the legal advice I was offering them. Eventually, under pressure from the Eletus and Lawal Pedro, quite a number of clients settled the Eletus claim in sums running into billions of naira. The Eletus and their lawyers continued to assert their claims per the fraudulently procured warrants, and the rapacious nature of their audacious land grabs meant that every unbuilt plot of land in Osakpa Agongi axis became fair game to them. This refusal to discriminate in the manner of their land grabs brought my office into contact with a rather interesting man, Alhaji Tunde Balogun, the immediate past commissioner for local government and chieftaincy affairs in the state at the time, who later became the chairman of APC in Lagos State. Alhaji Balogun searched me out. He came to my office of his own accord. I had never met him before he came to my office, and I had equally never heard of him. A particularly parsimonious man, he let on a skillfully shrewd and detailed negotiation process during the course of his negotiation of our professional fee. Alhaji Balogun had a story to tell. He owned 2 plots at Agungi, he said, bought from the Ojomo family long ago as the story went. Dele too had sold one of his plots to a developer of Igbo origin, who had gone pretty far in the construction of an estate to which one of his plots had become a tiny part. The second remained empty, even though he was convinced that it had also been sold to a third party. One of my favorite characters in the TV series, Game of Thrones, Lord Baelish, said, "Sometimes when I try to understand a person's motives, I play a little game. I assume the worst. What's the worst reason they could possibly have for saying what they say or doing what they do? Then I ask myself, how well does that reason explain what they say and what they do? I have mulled over these words as I have sought to understand exactly how the different threads are connected in the Eletu conspiracy. Justice Abdullahi was the chairperson at my wedding reception. She was the one that had employed me to work with my first employers, Basa and Partners. And we had not had any word to say to each other since May 2003, when she had visited my home and rudely sent me to fetch my wife for her, whilst she sat in her car at my gate waiting for my wife to bring her the checkbook to the office account to which my wife was signatory, even as my lady was the controller of the purse. The very same Justice Abdullahi, who was busy undermining my credibility and legal knowledge with key clients, was the very same person that was surreptitiously referring Alhaji Balogun to me. I became quite suspicious and began to sniff and dig around. I called up my wife, and then I called Mr. Mike Bayowa, my former boss and the normal head of chamber in my time at Basa and Partners. Both confirmed that Alhaji was Madam's client, and Mr. Mike further revealed that he was aware of the problems, having been earlier briefed by both Alhaji and Justice Oyekun Abdullahi. I became even more intrigued. Now, Alhaji's case was interesting to me for several reasons, but the most important thing about the case was the timing of the brief and its provenance. Bigger clients were being urged to settle with the Eletus by forces within the Lagos state government and judiciary. But here we are, paying counsel to a prince of the political establishment, a two-time commissioner of the state, and one that was still very much in the good books of the powers that be in the state. I became as intrigued as I was suspicious, and I took on the case after pretending to argue over the fees, in which I had little or no interest. I sued the Eletus and their buyer on Alhaji's instruction in suit number LD/3121/14. With Alhaji's case, I was able to make the case I had always made against the Eletu judgment. I plead particulars of their fraud. I filed evidence of the survey fraud. I sought to draw them out and into a defense of their shaky ground. We sued the Igbo developer, sued the Eletus, but I was rather unhappy when instead of fighting the claims before the court, the Eletus opted to settle the case on clear terms, considered the validity of my client's claim, and procured the Igbo developer to pay 30 million naira to our client for one of the plots. They went further to pay the commercial going rate, whilst accepting our client's claim to the second plot and vacating same immediately after. The Eletus agreed to pay 30 million naira in compensation for the encroached plot and gave up all claims in relation to the second plot. This is in spite of the fact that they were busy extorting billions from other people with the same judgments. These terms of settlement eventually became the judgment of the court. Now, you must understand how Lagos State works in order to understand the real significance of Alhaji Balogun's case. Lagos is in truth a village. Everybody knows everybody. There is something inherently incestuous about the Lagos Power Society. You will find very quickly, if you know who to ask, that everyone is somehow related. If they are not brother or sister from Oluwogbowo or Itailewa, it is that they went to some school, church, or mosque together. The elite of Lagos are all somehow related. Oyeko Abdullahi was the lawyer to the Ojomu chieftaincy family in her days as a lawyer. Legend has it that she was the one that brought Rotimi Williams into the Ojomu case. But what is beyond argument is her linkage to the Ojomu family. She was their lawyer and has remained a trusted member of the Ojomu in council. He knows more about the cases that culminated in the Supreme Court judgment. And she also knew everything that I had known about the Eletus fraud and Afe Babanlaole's shenanigans. Oyeko Abdullahi was aware of the effect of case M/779/93. She had the Ojomu's brief, as did Rotimi Williams Chambers. He knew that I was correct in my position that the Supreme Court could not have granted the Eletus more than the 10 hectares given to them in the case relied upon by the Supreme Court in its original ruling. She understood the incongruity of an Eletu claim for 254 hectares in the face of the clear judicial estoppel raised by their pleadings and the judgment in M/779/93. She knew and she sent Alhaji Balogun to me, knowing that I was correct in calling out the fraud. I know as a fact that Oyeko Abdullahi advised several clients to discount my legal advice on the Eletu case and did go to great length to disparage my knowledge of law. But the same person asked Alhaji Balogun to come to me for help. I did not fully understand why until the libel suit I had filed against Afe Babanlaole was assigned to her court. The last time I saw Lawal Pedro San, he was at a table away from mine at a Lagos party. A friend's mom was having her 80th birthday party somewhere in Ikeja. King Sunny Ade was on the bandstand. Mama was a sissy in her youth. Sunny had waxed an LP serenading her beauty, and men had fallen on Mama's mountains. It was a high-octane party, as is the practice in Lagos. The celebrant had given a list of her invited guests to the musician, and the first I became aware of the presence of the man was when Sunny Ade began to sing his praises. Lawal Pedro was the Solicitor General of Lagos State at the time that the Eletus got their judgment from the Supreme Court. I had become aware of the man very early in my practice life. My friend and second employer, Ademola Adesina Ogunlana, had worked for him before establishing his own law practice. And as I worked with Ogunlana, he would speak occasionally of his time with Peddy, as he called Pedro in those days, perhaps with some affection. I later came to hear enough from multiple sources to conclude from my own personal knowledge of Sherubawan that he must have coined the nickname Peddy, having characterized the man as a lovable rogue. That Pedro is a rogue is not in doubt. I will let you decide whether he be lovable or evil. At a meeting called by Lagos State, which was shared by Lawal Pedro in his capacity as the Solicitor General of the state, Pedro was given the task of finding a peaceful solution to the impasse by Adeipaye, the mild-mannered Attorney General of the state, who had been tasked with the duty by BRF, Fashola, and to avoid the likelihood of a breakdown of law and order. Lawal Pedro began to speak as if he was the retained counsel for the Eletus. In response to our objections to having the Eletus described as a chieftaincy family, whose claims are rooted in traditional land ownership, Pedro began to propound rather strange doctrines for the emergence of such families. That was when it began to get interesting, and the point where the extent of Lawal Pedro's shameless capitulation to the pursuit of filthy lucre became glaring and undeniable. The plot thickened when Agbenla, who was also a member of the multi-sectoral government team, became ambivalent about his own composite survey report. Surveying is essentially an actuarial science. There are no variances to be had in the interpretation of a survey. And once a surveyor has the information on the survey, he should not require further information before locating the land on the globe. For a drawing describing a property to be worthy of the name survey, it must describe the land with particularity. Agbenla had been compromised, istomized. I have come to the knowledge of how, by a rather fortuitous twist of fate, I became the catalyst required for the squabbling thieves to sheath their swords. The facts are all in the public domain. You just need to know where to look and what to look for. I will help you out. A little patience. Afe knew at the time he was accepting the Eletu's brief after their loss at the Court of Appeal that they were not only poor, they were indigent. These people were impecunious. The most basic of honest legal research would also have led to the inescapable conclusion that they had become entitled to only the 10 hectares that they had accepted in settlement of their claim in M/779/93. The Eletus had also sold these 10 hectares almost immediately after it was originally released to them. Afe knew all of this, but he had clearly impecunious people execute an agreement with him for legal services and had same notarized by a magistrate. Afe knew that the Gazette of Acquisition had rendered the rights in the conveyance inchoate. He knew that with Lagos State not being a party in the suit at any point, that the acquisition was not invalidated by the farcical gyrations of the Supreme Court. He was fully aware that M/779/93 stopped his client from ever fighting the acquisition in perpetuity and rendered his claims fraudulent, including any Supreme Court pronouncement discountenancing these facts invalid and nonsensical. But Afe knew that he could get the Supreme Court to do whatever he wanted and to rule however he asked. Pedro knew this too, and he being the original Lagos boy, showed Afe a bit of Lagos magic. Afe Babanlaole and the Eletus might have killed the buffalo, but they had no way of feeding from the carcass. We had turned the corrupt triumph at the Supreme Court into a Pyrrhic victory. And it was at this point that Pedro craftily inserted himself into the plot. He presented himself to the Eletus as the one that could get the corporate developers affected by the fraudulent judgment to pay up, and as the one that was best positioned to get them any form of recompense for their judgments. I have always enjoyed watching wildlife films and documentaries. I am particularly keen to draw parallels between the country of my birth and the animal world, and I warrant that you would be surprised to find how alike we are. When it comes down to it, if Afe Babanlaole might be likened to the lion, Lawal Pedro and the Lagos gang are the original African wild hyenas. They literally chased Afe Babanlaole off his scale. They repackaged the conspiracy, cut the losses, and went for the low-hanging fruit. As the trauma of the Eletu case left me increasingly disillusioned with the law, and the pursuit of corruptors of the court of justice became very personal to me, I took solace in comforting myself by using the Balogun case as proof that the clients that lost faith in my capacity to deliver justice to them were wrong. And even as I chafed at having been disabled by my bigger clients, I savored the pleasure of sticking it to the Eletus and the gloating told you so to the corporate players who were panicked into settling with them. This was enough until AD Hammer caught up with Afe Babanlaole. He dragged Lawal Pedro before the Lagos High Court and the Eletus before the ICPC. Interesting. So when they cheated Afe Babanlaole had to he had to kind of he procured the fraudulent judgment, right? Then they cheated him. So what did he do? He dragged the Eletus to the ICPC that they were fraudsters. Dragged the Pedro to the Lagos court that they are fraudsters. And he was the originator of the fraud, but he never benefited from it. I think now, we now know why Afe Babanlaole is even more angry at Dele Farotimi. How dare you go and say all of this? I did not make any money from this. I did not make anything. I was supposed to make billions from this, but I didn't make any money. I should. Now other people benefited. Now you wrote a whole book about me. Dele, Okay, let's continue. Sometimes in 2016, I started hearing rumblings of some serious fight brewing between Chief Afe Babanlaole and Lawal Pedro. I was told that Chief Afe Babanlaole had written a petition to the LPDC, alleging that Lawal Pedro had railroaded his client, Badamasi Eletu, into an agreement that circumvents his own legal agreement with the Eletus. About the same time, I also heard that the ICPC had been pressed into action against the Eletus, Lawal Pedro, and SB Joseph, which seemed quite incongruous, given the fact that the Eletus were not public officials. This event stirred an interest in me. I got my popcorn at the ready and waited to be entertained by the squabbling thieves. I had no idea that I was going to be forced into the fray. What transpired with the case is another story entirely, because it proved yet again to be another occasion where the Nigerian judiciary denuded itself, as well as Justice Oyekun Abdullahi. The judiciary at large confirmed above all else the Lagos conspiracy of the Afe Babanlaole to Supreme Court larger conspiracy. It is Afe's claim that he had a notarized contract for legal services with the Eletus. It is his claim that he discounted the original bill of $20 million to $10 million, and that whilst he had delivered on his obligation to prosecute the case at the Supreme Court, the Eletus had defaulted and had done so under the influence of Lawal Pedro San and SB Joseph. Ashimi was tangentially implicated because of the fraud he coordinated with the then Surveyor General of the state, Surveyor Agbenla. So Afe Babanlaole was supposed to make $20 million, right, from the whole fraud. Okay? Then he signed an agreement with the Eletus that I will get you the judgment, don't worry. After the Eletus lost at the appeal court, they met with Afe Babanlaole. They didn't have money. They didn't have so much money to give him. So that if Afe Babanlaole could help them, right, they will pay him $10 million. So Afe Babanlaole used his own trick at the Supreme Court to get a fraudulent judgment, right, a fake one, that, but he couldn't execute the judgment. He needed the Lagos people to execute it. In the course of execution, they discounted it themselves, cut down their losses, and they went for the low-hanging fruit, those ones who have never developed their lands. And they started collecting billions of naira. Upon collecting all these billions, Afe Babanlaole just hear about the money. They don't give them. So Afe Babanlaole now felt used and dumped. He decided to use his further influence, wrote the ICPC. I think this makes sense now. It makes sense now. No. At this point, you will understand why. It be like say, this book, Dele Farotimi used this book to open old wound. This was 2016, 8 years ago. Here you get. So Afe Babanlaole is like, you Dele, how dare you? You have been after me all this while. You have been the one that exposed the fraud. You are the one who we did everything to, and I didn't make any money from this. Now all these younger people are going to know that I am a fraud. I'm a very corrupt old man. But I didn't make money. I was cheated too. So if I say the money way Eletu and the rest no give Afe Babanlaole. That is why they want to collect the money Dele Farotimi make the royalty from this book. They're asking for 500. Oh, more. Interesting, right? This is interesting. No joke. But let's continue because we still have like about a few other pages to go. Okay. Anyway, when I saw Sobio Ashimi's name amongst the past parties stood by Afe Babanlaole, I laughed with unrestrained mirth. I had met him in Agbenla's office at the peak of the Eletus problem. He attended a meeting in Agbenla's office, and we were also there after I had obtained the composite survey report, and apparently, in coordination with Pedro, who had by then become the undisclosed attorney for the Eletus, and was fully aware of everything, Agbenla was seeking to give official cover to the Eletus attempt to doctor the survey and to provide additional information to explain away the inconsistencies and fraud. Ashimi came with an explanation that was not only fraudulent, it was also disingenuous. He had some cock and bull story about a shifting local originating point for the survey. And using a survey report I had commissioned the Unilag Survey Department to prepare, we demolished the spurious arguments he was raising. But I needed not to have worried. My clients were not the intended consumers of the fraud being concocted. That part of the scheme is the emerging fraud on the state and the expected solution to the many problems birthed for the conspirators. When Afe found that he had been schemed out of the game and that Pedro was reaping from his exactions, he was enraged and sought to understand what had happened and why the fact that he had gotten the Supreme Court to do the impossible was not enough to make the Lagos crew deliver the execution of the revamped judgment. When Amina Ogi, GSC, railed against that woman that I played a video here yesterday, was it yesterday? Or, yeah, it was yesterday or 2 days ago. Yeah, that woman, she's mentioned in this book. When Amina Ogi, GSC, railed against Afe Babanlaole's professional conduct or misconduct in the Bayelsa case, he did so either as an ostrich or out of ignorance. Afe has been corrupting the Supreme Court from ages past, and he has led it to commit the most egregious act of evil and wanton injustice. Afe knows what our ladyship does not know or pretend not to know, that justice does not live in the Nigerian court. And you can get the court to do whatever you want as long as you know who to speak with and who to pay. Afe's letter to Ayotunde Phillips, then Chief Justice of Lagos State, showed how frustrated he had become about the inability to execute the fraudulent judgment. In spite of the fact that he had the Supreme Court to do what it had never done before, and exactly what Amina Ogi GSA presumed to rail against, Pedro, SB Joseph, and the Eletus formed a new confederacy and had neither room nor use for Afe Babanlaole, who had overestimated his own importance to the plot and failed to discern that he had effectively become unnecessary to the new plotters. I am convinced that Pedro muscled in on the plot and was not a part of the original plot. His de facto headship of the state's committee charged with finding a resolution was the critical factor in his emergence. In going through processes filed by Afe Babanlaole, I came across a letter he had written to the then Chief Justice of Lagos State, Ayo Phillips, where he had violently libeled me and described me in extremely disparaging terms. Afe is so enmeshed in his corruption that he has lost all sense of propriety and or fairness. I will let you decide the fairness of the doyen of Nigeria injustice and lawlessness in describing the younger counsel, who had only sought the cause of justice from the well of justice into which the old man had always pissed. I immediately caused counsel in my office to write a letter to the old man and made clear that I was not going to be satisfied with anything short of an apology and a retraction. I have absolutely no interest in taking Afe Babanlola's corrupt money, but I was not going to allow a corrupt, amoral man, devoid of any integrity, to define me for posterity when none of us would be around to dispute the hagiographic account of the event. The doyen of Nigerian illegalities ignored to offer any acknowledgement of the letter and arrogantly refused to retract nor apologize. I caused writ to be issued against Afe Babanlola's son for libel. I told everyone that cared to listen, including my trusted partner and friend, Raf Nwoke, that the case would never be allowed to proceed to trial and that it would be killed within the system. Afe simply had no leg to stand on and would not dare to join issues with me in court. I spoke with the finality of divinity, but I did so only because I know my country and the extent of the wrath that my suit against Afe was threatening to expose. I was bang on the money. Afe Babalola was imperiled by the suit I filed in court. It was designed to blow open the tawdry details of his dirty deals with the Supreme Court. But the suit also represented a threat to the Lagos part of the conspiracy. It was one thing to be having a quarrel amongst thieves. Each knew how far they might push their claim, but it is quite another thing to get into a rofo fight with a man seemingly incapable of walking away from a fight. The Eletu conspirators found a semblance of peace when I filed the suit against Afe. The perils that were being faced by all key members of the twin camps of conspirators preoccupied their minds, and thanks to the verbiage that had been released by the camps for public consumptions before I entered the picture with my libel suit against Afe, it is possible to piece together key fragments of what took place. I must close with a caveat. I am not privy to what happened in the conclaves of crooks, but I do remember that I have heard it said, if it waddles like a duck, quacks like a duck, it is most likely a duck, or similar words to that effect. In the early days of Eletu saga, I was often heard making an equivocal declaration that I would burn my wig and gown in protest and on the steps of the Supreme Court if Eletu judgment was ever enforced. I am happy to have been spared the nuisance of making a spectacle of myself. In order to draw attention to the madness of the court, I knew exactly what message I was passing when I repeated that statement in front of the likes of Lawal Pedro, who I knew had repackaged himself as the Eletu's lawyer. He had, to my knowledge, had the brief of defendants through his remedium chambers, whilst involved in their prosecution by the states, and he had acted as counsel to parties suing the state when it was his duty to defend the state. I was making it clear to all that I was happy to die in defense of what I knew to be true. Pedro exploited that resolve to further neutralize Afe's influence over the Eletus and thereby strengthened his own importance to the conspiracy if they were to get anything of substance from the puerile judgment and their Pyrrhic judicial victory. This resolve became a key factor in the negotiation that have ensured the cessation of hostilities among the competing interests in the conspiracy too. When the conspiracy was reconstituted, Pedro was exactly where he wanted to be. He became the deal maker. The Eletus took whatever they could get off the victims with Pedro, the constant broker, and Pedro began to help them to package a deal reminiscent of the one that the government had done with the Oluwa Shiftansi family after they had won the court judgment in Ijora axis of the state. The deal, structured by Lawal Pedro, extracted money from the corporate players in the neighborhood, but considerably less than the Eletus had been originally offered by the panicked parties. The sweetener in Pedro's deal was the peace and calm it brought to the traumatized business entities. The Eletus, having been stymied after the initial bombast of the early days, became more reasonable under Lawal's influence. And he made them see further reason for accepting the settlement by influencing the state to offer the Eletus land to be reclaimed from the lagoon bed. Land to be reclaimed from the lagoon bed is important in the resolution of the squabble within the Confederacy. The expected reward for the sickening injustice laid in the Eletus paying up on the agreement that they had signed with Afe Babanlaole to pay $10 million. The Eletus had no money for anyone at the time. Afe was signing them on. And the assumption was always that the corporate players expected to be caught up in the trap would be the ones to be squeezed into coughing up the monies. I am not privy to what was paid by anyone, but the Eletus began to flash the cash. Rolls-Royce cars began to compete for parking space in the Oval that was home, and the younger ones began to live the high life. Afe's findings revealed Lawal's role, and Afe dragged Lawal into the fight. This fight ended with my suit. In one of the interviews granted by Pedro at the peak of his dog, did you hear about Eletu families? People who sold land and they are living large. Some of them are the ones who are now asking the Igbos to go back to Anambra. After they have sold all the lands, some of them they fraudulently acquired their family lands, their ancestors' lands. They bought themselves, they built themselves mansions. They married many wives. They were buying themselves Rolls Royce, expensive automobiles. They were living large as billionaires. Now that they barely have any land to sell anymore, some of their runukus, they are now asking those people who bought the land, who built the entire place up. They are looking for a time that maybe there's going to be a civil war, so they can chase all of them away. Igbos, go back to Anambra. You want to control our Lagos? Go back to where you come from. Meanwhile, they sold all their family land, family houses, everything, just to flex, to marry wives. Today, they are now saying that the Igbos are trying to take over Lagos. Remember that? Oh? The Eletus are very poor. They were very poor. It was Afe Babanlaole's fraud that turned them into billionaires. I don't know if they still have the money. If you go and see some of their families right now, they are wretched, except for those who directly benefited from that money. Billions and billions. All right? They are wretched now. So many of them. Omonile Leko. They got all the money, spend the money, bought themselves all the fancy stuff, And now that they have barely nothing to sell, they are now campaigning for everybody to go back to where you come from. Leave our Lagos alone. Even if you leave Lagos for them, right? They will still resell the whole place again and use the money to marry wives and live large. Bunch of useless people. Anyway, let's continue, right? In one of the interviews granted by Pedro at the peak of his dog fight with Afe, he let it be known that he had gone to Ekiti to see the old Koja, that he had explained himself to the old man, and that the man had come to see that he had not done anything to steal or influence the Eletus. Nothing could be further from the truth. Afe was offered 2 incentives for the settlement of his problems with Pedro, and I am aware of both, even as I must concede that I do not know the details. Afe was offered part of the land that had been packaged for the Eletus by the Lagos State conspirators. Pedro said as much in one of his press comments where he made the announcement of ongoing reconciliation efforts between the parties. I am not aware of the details of what Afe was offered, but I am convinced that the Afe part of the Confederacy was settled with the promise of a portion of the land. But there was a second incentive. This was the promise to get rid of the nuisance that my libel suit against Afe represented. I knew when I was filing this suit that Afe was not in a position to ever defend the suit. He has no defense, and he never anticipated that I would ever become aware of his libel. And if he did, he wasn't concerned about what a mere mortal like me could do to a god like him. Afe was offered assurances that he didn't worry about the case. The Lagos conspirators had it in hand and would extinguish the fire. Recall what I had told you of Lagos society. Everybody knows everybody. Lagos power elite is highly insentious. It is a closed group. There are circles within the several circles, and it takes the initiate to discern that there are neither religious nor political divides amongst the Lagos ruling class. Pedro had spent a lifetime in the Lagos judiciary. He rose to head the Justice Ministry as the SG. He was a good son of the system and would probably have made Attorney General if he had been considered useful when Ambode emerged. He knew he would deliver on his word to Afe, assuming that he hadn't concluded before going to Ekiti for the peace meeting with Afe. By the time I was filing my suit on the 19th September 2016, Pedro had been removed from office as the SG, Solicitor General, that's the SG. He had made strenuous effort to be promoted upward and made the Attorney General at the dawn of the Ambode era. But Pedro had no immediate value to the powers that be in Lagos at the point in time. He was taught to pasture to the raucous joy amongst lawyers and staff of the Lagos State Ministry of Justice, where he was almost universally derided for his avarice and legendary parsimony. I first became aware of his problems with Afe from tales borne to me by staff of the state judiciary. The assignment of the case took forever at the court registry, and when it was eventually assigned, it was to the court of Oyekon Abdullahi, my former oga, chairwoman at my wedding reception, sworn enemy of over a decade, and newly transferred to the Lagos division of the court from the Ikeja division. I saw her transfer from Ikeja to Lagos at the material point in time as a tad too much of a coincidence, and my knowledge of her legendary tactlessness affirmed my belief that she had volunteered herself to do the hatchet job required to kill my case. Immediately the case was assigned to our court, I called my former boss, Mr. Mike Bayowa, and I complained strenuously about the audacity of justice. Oyekon Abdullahi assuming jurisdiction in a case that asked me as a named party. I mailed the idea of writing a letter to demand that she withdrew from the case, but decided against this, as I felt that it would be seen as an attempt by me to scandalize her for no reason. I even had it pointed out that she was merely the pretrial judge. I knew I was right to be paranoid about her, and I was proven prescient in my deductions by subsequent events. The case suffered several unnecessary delays at the instances of the court and the defendants. The climax was when Afe brought a preliminary objection to the suit. It was founded upon some nebulous claim to judicial privilege by the unschooled senior citizen. The legal incongruity of this defense was lost on the unlearned silk and his crop of corrupt wigs. But they always knew that they were working for the question to the answer. After the dilly-dallying was done, Oyekon Abdullahi heard the motion and the counter-argument, and thereafter adjourned the case sine die for a ruling on the PO to be delivered. Sine die means until further notice, like he adjourned the case until further notice. Several months rolled by, and the court's ruling was not forthcoming. I caused at least 2 letters to be written to the court's registrar, demanding to know when the court would be sitting to deliver his ruling. The letters remained unanswered till this day. We became aware of the court's ruling only because a counsel sent to the court to make inquiries was told by the registrar that the ruling had been delivered 9 months after the close of address, and without as much as an SMS notice to the counsel on the court's own record. I was happy and contented with her ruling. I am happy with her ruling because it helped me to make sense of seemingly disconnected strands of the Eletu story that had hitherto made no sense until she inserted herself into the narrative. I have always hated bullies. T.A.O. Abdullahi is defined by a garrulous bellicosity. He is bereft of diplomacy, loves to dominate our environment, and is given to indiscretions that a more reflective person would have avoided. He overestimated her powers over me as my first boss when she ignored my resignation letter and presumed to order me back to work, and she has again done so when she offered herself as the solution to the problem that my suit represented to the Eletu Confederacy. Oyeko Abdullahi was brought from Ikeja division of the High Court to do the job of the Lagos Confederates, and she did not even have the refinement to pretend to be anything but biased, prejudiced, and incapable of delivering justice. The ruling she delivered in my suit against Afe surprised only her. I will leave it to you to decide how much the cause of justice was served by her attached ruling. I had what I needed to prove the extent of conspiracy and just how far they were prepared to go in the pursuit of their common purpose and in subjugating law and justice in the pursuit of corrupt private interests. My former boss is a social butterfly and climber. She has and is given to delusions of grandeur. She enjoys being the center of attraction, and she has an abiding need to be accepted as a part of some inner circle. This need to be seen as important to the workings of a power system is what has made her so careless in this regard. The moment that my case against Afe was assigned to her court, I knew exactly what she would do. And I was also looking forward to being right. I thank her for being so predictable. Oyeko Abdullahi wrote herself into this book. I had no business with her until she showed her hands. First, with Alhaji Balogun's sneaky referral, and then by the inglorious role that she's assigned to herself in my suit against Afe Babanlaole. Do I think she was originally part of the plot? No, I do not believe so. But she muscled in on the conspiracy once I blew up the plot with my works. The Ojomus wouldn't have talked to Atilade in October 2013 without her knowledge. He's a longtime friend of Atilade and her sister, and a longtime friend and confidant of the Kabiyesi and Balogun Opajero. What and whose interest she has pursued in the Eletu's case is for her to explain to her conscience. But she has not served the cause of justice. I have seen injustice everywhere within the Nigerian court system. I am a lawyer with over 2 decades of law practice behind me. I have interacted with our judicial system as a practitioner, as a victim, and as the aggrieved. There is no justice to be had in our criminal justice system, and I have become convinced that the system itself is criminal and completely incapable of delivering justice to anyone, because the justice system is part and parcel of a government or governance system that cannot afford to allow the equality of citizens before the law. The equality of citizens before the law. I knew that I would not get justice from the courts when I sued Afe Babanlaole. Any and all illusions I might have harbored equally evaporated the minute Oyeko Abdullahi was assigned the case and obliterated the minute that she ruled as she did. She gave a judgment that is manifestly unjust and impossible to explain within legal and rational parameters, and compounded the injustice by a brutal exclusion of myself or counsel, as she presumed to throw my case out of the court. But she and her confederacy have miscalculated terribly. I sued Afe Babanlaole because I was always going to blow his dirty, tawdry secrets. I did not know how long any of us had to live, and I did not want to be dealing with the idiotic arguments that I could envision of Afe's proteges, arguing that I was slandering the dead if the book was to be published after his demise. He is already well in his 80s. I have offered him the opportunity to defend himself. He went to extraordinary length to deny me my day in court. Recall that I had explained the casual recklessness of Oyekun Abdullahi and our pathological need to be loved and accepted by those he believes to be our superiors. All these factors brought her into this story. He volunteered for the hatchet job that she did. He had every reason under the sun to have asked to be excused from being involved with the case, but she predictably discounted what common sense should have wanted her to run away from. Nobody have insisted on her being the one that did the death on me. If she had told them her story, she could have told them of the new wig that she employed, as she was also newly sworn to the judiciary. She could have told them of how she was the chairwoman at my wedding reception. She could have told them about how her greed, disrespect, envy, and the resultant hate in her spirit ensured that despite 2 attempts by me to make peace over the years, he had been too blinded by hatred to embrace the peace I had offered. She volunteered for the job. I had known from the day she was assigned the case that she would do exactly what she did. I filed the case and allowed it to remain in a court sans protest because I was already aware of exactly what I would do in response, which is to write this book. The end. So, brethren, there is an annex, annexure to this, right? Which is the background of the case that is referred to in this, in this book, and that, is what. In fact, hang on. I think I could read you a part of that. Yeah, I think that's just based on the reason above and okay, yeah, okay. So this is one here when it made the ruling. Okay, said conclusion: the ruling of 18th of March 2014, which proposed to vary the consequential order by substituting 10 hectares for 216.75 hectares, 758 hectares as no foundation in the judgment of the 12/7/2013, as 12th of July 2013, is therefore a fresh order which cannot be considered a consequential one. I therefore must conclude, based on the reasons above adduced, that the Supreme Court of Nigeria acted ultra vires its rules when it made the ruling of 18th March 2014. The end. So I hope I have helped a lot of us that will find it a bit of a work to sit down and read this expose. Now we know why they are so mad at Dele Farotimi. Okay, now we know that there can still be a lot of them that are going to use their judiciary to institute other different funny cases against Dele Farotimi in the coming days. Now we know why they want him locked up, right? In their court in Ekiti, denying bail. And while Afe Babanlaole is running away from court, we now know why Afe Babanlaole is not suing Dele Farotimi directly, and is using his his proxies to sue Dele Farotimi. Now we know why. We know how the entire system, that even if you go to the Supreme Court and the Supreme Court rule in your favor, there are some power that be in Nigeria that can actually change it and make the Supreme Court to appeal itself, to rule against itself again. Usually when Supreme Court rules on anything, it is final, but not in Nigeria, in a corrupt, a corrupt establishment in Nigeria. So now we know why they are coming for him. So any of you who probably didn't know that Dele Farotimi knew that once this book is published, they will come for him, then maybe now you know. So you don't need to beg these criminals. Dele Farotimi doesn't need anybody to beg these criminals or plead for out of court settlement. No. This is a piece of work that is going to outlive Dele Farotimi as well as Afe Babanlaole as well. Now you know that justice is not in Nigerian courts, especially if it somehow crosses the path of the career criminals in Nigeria. You will never win. Now you know. Thank you so much for your time, and thanks you so much for listening. Let's go get ready for later this evening. It's been a pleasure. Right? It's been a pleasure.
Even the one you talk about our crude oil in the facilities abroad, during Buhari's administration, I'm aware 2 teams were sent to China. They came back and confirmed that we have crude oil there. Later, NNPC hired Afe Babanlaole to go on television, advertise on the papers that the whistleblower is a liar, that nothing like that happened. Even
he's a career criminal, right? And we hope that the generation that should know now knows. Enjoy the rest of your afternoon. I'm going to see you later. And to some of you who probably missed yesterday's broadcast, it's going to come up very soon as a replay. You can watch it then. Good afternoon.
Mayegun làwa mọ̀ làmọ̀ tó dòdòdò.
Mayegun diary, Nayibi #1.
Mayegun làwa mọ̀ làmọ̀ tó dòdòdò.
Mayegun diary, Nayibi #1.
Mayegun ti dé o, ọ̀rẹ́ ará ìlú.
Mayegun diary, Nayibi #1.
Lórí Facebook, lórí YouTube.
Mayegun diary, Nayibi #1.
Gbogbo bó ṣe ń lọ ni Mayegun já wa sí.
Mayegun diary, Nayibi #1.
Àṣírí ọ̀jẹ̀lú kì í bò níbẹ̀ o.
Mayegun diary, Nayibi #1.
Bó bá ṣe eré, àní Mayegun máa wí.
Mayegun diary, Nayibi #1.
Ó sì tún ṣe eré, wàá gbọ́ níbẹ̀ o.
Mayegun diary, Nayibi #1.
Mayegun diary politico.
Mayegun diary, Nayibi #1.
Godfatherism kò sí lọ́rọ̀ Mayegun.
Mayegun diary, Nayibi #1.
Ẹ farabalẹ̀ sẹ́ o kẹgọ́rọ̀ lẹ́nu o.
Mayegun diary, Nayibi #1.
Àní Mayegun làwa mọ̀ tó dòdòdò.
Mayegun diary, Nayibi #1.
Àní ẹ̀sùn ràkì.
Mayegun ti dé. Mayegun ti dé.
Ọ̀jẹ̀lú ẹ̀sùn ràkì.
Mayegun ti dé.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Lórí Facebook.
Mayegun ti dé.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Lórí YouTube.
Mayegun ti dé.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Bọ́ bàbá gbé wúrẹ́.
Mayegun máa wí.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Ijó ìgbádìyẹ.
Mayegun máa wí.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Presido bá rúfin o.
Mayegun máa wí.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Kí gómìnà kówó jẹ.
Mayegun máa wí.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Ọlọ́pàá ti ń darí bá.
Mayegun máa wí.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Aṣòfin ti ń rúfin o.
Mayegun máa wí.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Òpùrọ́ olóṣèlú.
Mayegun máa wí.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Ọ̀jẹ̀lú ẹ̀sùn ràkì.
Mayegun ti dé.
Àní ẹ̀sùn ràkì.
Mayegun ti dé.
Mayegun ti dé. gbogbo ọ̀jẹ̀lú ẹ̀ súnra kì. Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kì. Ṣùgbọ́n ní bá ti ṣe èyí tó yẹ kí wọ́n ṣe ọmọ bá dèrò ní fi wọ́n níran o.
Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kì. Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kì. Ṣùgbọ́n ní bá ti ṣe èyí tó yẹ kí wọ́n ṣe ọmọ bá dèrò ní fi wọ́n níran.
Wọ́n fowó bẹ́ẹ̀ o Máyégún ó sọ pé wọ́n ò bẹ́ẹ̀. Wọ́n fowó bẹ́ẹ̀ Máyégún ó sọ pé wọ́n ò bẹ́ẹ̀. Oníkan ṣáàtì ṣe èyí tó yẹ kí wọ́n ṣe fáwọn ará ìlú tó gbé wọn débẹ̀ o.
Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kì. Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kì. Ṣùgbọ́n ní bá ti ṣe yìí tó yẹ kí wọ́n ṣe ọmọ bá dẹ́rọ̀ òní fi wọ́n níran.
Kì máa yí ṣe eré ọ̀rọ̀ yìí kì í ṣe ẹ̀fẹ̀. Kì máa yí ṣe eré ọ̀rọ̀ yìí kì í ṣe ẹ̀fẹ̀. Ẹni bá ti lè lẹ́bọ̀ lẹ́rù o ọmọ bá dèrò kàṣà ìtú wọn síta.
Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kì. Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kì. Ṣùgbọ́n ní bá ti ṣe yìí tó yẹ kí wọ́n ṣe ọmọ bá dẹ́rọ̀ òní fi wọ́n níran.
Tẹnitẹni ọmọ Máyégún ọ̀rẹ́ ara ìlú mọ̀mọ́ ni ó fọlọ́hún ṣọ́ ẹ̀ bá kìlẹ́bù. Lóòótọ́ olódodo ìlú ọ̀tá ìlú mọ̀mọ́ ni ìwọ ṣá máa ń ṣọ́ra kò sì mọ́ bẹ̀rù. Bọ́tà ń lè rí bóníṣègùn lé káwọn mọ̀mọ́ fi ṣera wọn ni ó ti dẹrùn tí wọn ò gbọ́dọ̀ sì mọ́ bẹ̀. Èèpo ọ̀gọ̀ lọmọ bá dérò tàjẹ́ ò gbọ́dọ̀ jẹ́ ó ti dọba lórí àbínú ẹni kò sì mọ́ bùyà. Àìsíwọ́lu ní ẹnìkẹ́ ìgbódì ẹyin lábàrá o ó kó ẹni tó bá dán o àkàmù. Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ túnra kì. Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ túnra kì o. Ẹni bá ti ṣe yìí tó yẹ kí wọ́n ṣe ọmọ bá dèrò òní fi wọ́n níran o.
Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kì. Máyégún ti dé gbogbo ọ̀jẹ̀lú ẹ̀ súnra kì. Ṣùgbọ́n ní bá ti ṣe yìí tó yẹ kí wọ́n ṣe ọmọ bá dẹ́rọ̀ òní fi wọ́n níran.